The Senate Committee on Civil Rights, Judiciary, and Public Safety is called to order. Will the clerk please call and announce the roll?
Chair Chang.
Here.
Senator Schenck. Here. Senator Voino. Here. Senator Irwin. Here. Senator Santana. Here. Senator Runstead. Here. Senator Johnson. Here. Madam Chair, you have 7 members present. There is a quorum.
Thank you. I'll entertain a motion to adopt the committee minutes from the April 13th meeting. Motion made by Senator Schenck. Without objection, the minutes are adopted. We're going to take some votes on the bill package that we heard testimony on last week. The bills related to sexual assault prevention, and I believe we have a few cards to read in.
We do, Madam Chair. In support of Senate Bill 66 and not wishing to speak, Dr. Cheryl Kennedy, representing the Michigan Department of Education. In support of Senate Bill 66 through 68 and Senate Bill 73, not wishing to speak, Jess Averill, representing Michigan Domestic and Sexual Violence Prevention and Treatment Board. And the last card, in support of Senate Bill 236, neutral on Senate Bill 236 is Jess Averill, representing the Michigan Domestic and Sexual Violence Prevention and Treatment Board. And that is all of the testimony cards, Madam Chair.
All right, thank you very much. Before we vote on the bills, we'll have a comment from Senator Schenck.
Chair, I just wanted to say that a lot of times in the Senate, we bills that make a big difference in people's lives or address something that happened in their life that they hope never happened to anybody else. And this is one of those times for me because when I was in college and went to at University of Michigan, which I dearly, and went to student medical services and to be examined for migraines, Dr. Anderson inappropriately touched me, not in the same way that he touched quite people, and I thought he creeped, but it took me a while to realize that was a sexual assault, and that this bill is actually designed to prevent that kind of thing from happening to anybody else. In terms of long-term trauma, I tend not to go to the doctor. Maybe that's part of the reason why, I don't know. But I don't want this to happen to anybody else in any of the many, many forms that he abused people, many who may not have even realized that he was doing it for inappropriate reasons. So thank you for the opportunity to comment, and I just really appreciate everybody who helped bring this bill package together.
Well, thank you, Senator Schenck, and I appreciate you sharing that story. And unfortunately, we know how deeply people are impacted by sexual assault, and I'm looking forward to the impact that these bills will make once they are signed into law. I'll now entertain a motion to report Senate Bill 66 to the floor with recommendation that the bill pass. Motion made, Senator Schenck. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenck.
Yes.
Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
Yes.
Senator Johnson.
Yes.
Madam Chair, on the motion to report Senate Bill 66, there are 7 yeas, 0 nays. The bill is reported.
Thank you. I'll now entertain a motion to report Senate Bill 67 to the floor with recommendation that pass. Motion made by Senator Voino. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenck.
Yes.
Senator Voino. Yes. Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
Yes.
Senator Johnson.
Yes.
Madam Chair, on the motion to report Senate Bill 67, there are 7 yeas, 0 nays. The bill is reported.
Thank you. I'll now entertain a motion to report Senate Bill 68 to the floor with recommendation that the bill pass. Motion made by Senator Irwin. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenck.
Yes.
Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
This is that bill.
Yes, Senate Bill 68
Yes.
we're on. Senator Runstead is a yay. Senator Johnson.
Yes.
Madam Chair, on the motion to report Senate Bill 68, there are 7 yeas, 0 nays. The bill is reported.
Thank you. I'll now entertain a motion to report Senate Bill 69 to the floor with recommendation that the bill pass. Motion made by Senator Santana. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenck.
Yes.
Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
Yes.
Senator Johnson.
Yes.
Madam Chair, on the motion to report Senate Bill 69, there are 7 yeas, 0 nays. The bill is reported.
I'll now entertain a motion to report Senate Bill 70 to the floor with recommendation that the bill pass. Motion made by Senator Johnson. Will the clerk please call the question?
Chang.
Yes.
Senator Schenk. Yes. Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana. Yes. Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to report Senate Bill 70, there are 7 yeas, 0 nays. The bill is reported.
I will now entertain a motion to report Senate Bill 71 to the floor with recommendation that the bill pass. Motion made by Senator Runstead. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenk. Yes. Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana. Yes. I'm sorry, Senator, yes? Yes. Yeah, thank you. Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to report Senate Bill 71, there are 7 yeas, 0 nays. The bill is reported.
I'll now entertain a motion to report Senate Bill 72 to the floor with recommendation that the bill pass. Motion made by Senator Schenk. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenk. Yes. Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana. Yes. Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to report Senate Bill 72, there are 7 yeas, 0 nays. The bill is reported.
I'll now entertain a motion to report Senate Bill 73 to the floor with recommendation that the bill pass. Motion made by Senator Voino. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenk. Yes. Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to report Senate Bill 73, there are 7 yeas, 0 nays. The bill is reported.
On Senate Bill 236, we do have an amendment from Senator Irwin. Senator Irwin, would you like to comment on your amendment?
Yeah, thank you, Madam Chair. There were advocates who encouraged us to add the word alcohol to this legislation. And page 3, line 7, basically, I think any honest reading of the current language would include alcohol as an intoxicating substance, but given the way, alcohol is the most widely abused drug and the most likely one to cause problems, we thought we should call it out, and it was suggested by some advocates. So I'm proposing that we amend the bill and do some foot stomping language here by adding alcohol directly to other intoxicating substances.
Thank you. I'll now entertain a motion to adopt Amendment Number 1 to Senate Bill 236. Motion made by Senator Irwin. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenk. Yes. Senator Voino.
Yes.
Senator Irwin.
Yes.
Senator Santana.
Yes.
Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to adopt the Irwin Amendment Number 1 to Senate Bill 236, there are 7 yeas, 0 nays. The amendment is adopted.
I'll now entertain a motion to report Senate Bill 236 as amended as a clean substitute to the floor with recommendation that the bill pass. Motion made by Senator Irwin. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Schenk. Yes. Senator Voino. Yes. Senator Irwin. Yes. Senator Santana. Yes. Senator Runstead.
Yes.
Senator Johnson. Yes. Madam Chair, on the motion to report Senate Bill 236 as amended as a clean substitute, there are 7 yeas, 0 nays. The bill is reported.
Thank you very much. And now we will move on to the juvenile life without parole bills, and would like to invite Senator Irwin up to speak about the bills.
Thank you, Madam Chair, for the opportunity. Thank you, committee members. I am proud to be sitting here introducing to you legislation that would end juvenile life without parole in Michigan and our statutes with certain state and federal Supreme Court decisions that have been made in this regard that stipulate that sentence juveniles to life without parole without additional due process is unconstitutional. I'm really also pleased to be sitting here working along with Senators Santana and Schenk, as well as Senators Geis and Kavanaugh on this package. And so what this legislation would do is it would eliminate juvenile life parole in Michigan and align our state with 27 other states that have taken steps like this to comply with the U.S. Supreme Court ruling in Miller v. Alabama. That ruling declared that automatically sentencing a child to life without parole is unconstitutional as cruel and unusual punishment. Essentially, that youth who commit crimes should have a chance of rehabilitation. And we've heard loud and clear from our Department of Corrections that when they have young people in their facilities that have no light at the end of the tunnel, no opportunity for rehabilitation, no opportunity for redemption, that makes their life more difficult. So these bills would also eliminate mandatory life without sentences for 18-year-olds, for those up to 19, and require consideration of their age and maturity and other factors that are outlined in the Miller v. Alabama decision. Taken together, our bills eliminate life without the possibility of parole for youth under 19, provide a minimum sentence of no less than 10 years and a maximum sentence of no more than 60 years, also allowing for parole review after 10 years where the incapacities of youth must be considered. And the incapacities of youth are just shorthand for the Miller factors, the factors that the U.S. Supreme Court said had to be considered in these kinds of cases. Things like the juvenile's age, things like the family home environment, the circumstances of the offense, certainly, and also the role that the juvenile had in the offense, as well as any influence from peer pressure. And that's because scientific research shows that there are key developmental differences between youth and adults that impact youth decision-making, impulse control, and susceptibility to peer pressure. These differences don't excuse youth from accountability from their actions, but the U.S. Supreme Court and the Michigan Supreme Court have repeatedly recognized that because of these differences, youth are less blameworthy and certainly more capable of change and rehabilitation. Eliminating juvenile life without parole does not allow for the automatic release of offenders prior to their minimum sentence, rather provide an opportunity for review by the parole board after a reasonable period of incarceration, one that takes into consideration the unique circumstances of each defendant. So with that, I know that we've got a lot of individuals in the audience who want to testify, and I want to just personally apologize to them for making them wait for the start of the hearing, because I know that everyone's time is very valuable, and as is this committee. So thank you, Madam Chair.
Thank you very much. We do have a question from Senator Runstead.
Thank you. You outlined the Supreme Court ruling pretty well that all of these youthful offenders that had a life sentence have to be resentenced, and that's probably not a bad policy. In reading here, the office has represented 193 of the 364 juvenile lifers that were required to be resentenced under Montgomery. All but 8 of those cases resulted in a reduced term. So the idea that the courts and the prosecutors are just willy-nilly resentencing all of these juveniles to real life is obviously not the case. 8 out of 193 in this case. So my suspicion is that those 8 were not as defined here. Everything pertaining to this is the individual's age and maturity at the time of the offense, the family and home environment of the offense, and the circumstance surrounding the offense, what was the peer pressure. What I think is left out of that equation was the habitual and the violent aspect of maybe that 8 that the court was to take a look at and say, based upon what we see with this individual, maybe a sociopath clinically cannot be rehabilitated. Rehabilitation makes them worse. So I have a real problem of this automatic nature of things that the courts obviously are really looking at these cases hard and saying these 8 are so dangerous we can't release them. So I just wonder what your response to that is.
Yeah, my response to that would be that I'm not looking at the exact same numbers as you are, so I'm not able to quote them, but you're pointing out that a small percentage of those that have been fully re-adjudicated through the process have actually been reassigned with juvenile life without parole. But the cases that haven't been re-adjudicated are in general the harder cases, and I think that's one of the reasons why you're seeing the numbers come out that way. But I think a more global response to what you're saying is that I think what we're talking about here in the legislature, independently from what the courts are talking about reviewing individual cases, is what should be the going forward approach to these kinds of cases. And I think we're going to hear a lot of testimony from folks about how often these folks do reoffend, which is almost never, and some testimony that will support the idea that the parole board is the right board and the right body to look at whether an individual who's done 10, 20, 30, 40, 50 years has been rehabilitated, and whether they're a different person than when they committed their crime at 17, for instance. And I would also point out that the proposal that we've made here tops out at 60 years, which is essentially life for a 17-year-old.
Just curious if you had read that report that was cited in terms of the recidivism? Did you read it or seen it?
I'm not sure which report you're talking about. I've seen numbers on
It's the one you
recidivism.
just cited, that it was like 1.2% our recidivism rate.
I've seen these numbers, yeah.
Yeah, I've seen the numbers too, constant. I've not seen the report. Somebody can get that to me. I'd appreciate it. Thank you.
Okay, yep.
All right, Senator Johnson.
Thank you, Madam Chair, and thank you. I think we do have to look at many different avenues that we can do to make sure people have second chances that deserve them. But I am concerned, as a clinical social worker that went to Wayne State and worked at Children's Village Camp, Oakland, and probate court, if you have a kid that's called antisocial as soon as they turn 18, if they're the definition is psychopathic or behavior. They don't have a conscience. And we know that, as Senator Runstead said, that unfortunately, we don't know how to fix that yet. Hopefully someday we do. I know one thing, we need to get involved earlier in people's lives that are going through really bad events. If they have parents that are sociopaths, commonly sociopaths. But on page 9 and 10 of the report, and I don't think Dr. Keating's here, so it does say that there's really no way to have success to date in determining when you have people that do crimes that are against people, not chattel, not stuff, not a car. When somebody hurts someone else, that we really don't know how to figure out whether they're going to be a problem when they get released to others in public, because they have done that. And so I was just wondering, how would you make sure that we have a very, very high percentage of people that aren't released that are sociopaths that don't have a conscience and have hurt people in the past?
Yeah, I mean, I think we need to look at the standards that the parole board operates under and look at the statistics of what the parole board does. And I think at some point during this hearing, you might hear some folks come forward and say, hey, look, the parole board tends to parole about 80% of people. Well, that means that they're not paroling 20% of people. And I think that that is an indication that the parole board is doing a good job of saying, look, here's a set of people that have not persuaded us sufficiently that they have been rehabilitated and can be successful on the outside, and here's a group that is. And what I'm proposing here with this legislation, what we're proposing here with this legislation, is let's give those tools to the parole board, who I think have been doing a pretty good job of making that determination, particularly when it comes to these juvenile offenders, because these juvenile offenders are the ones who are most likely to change, most likely to be rehabilitated, most likely to look at the world differently when they're 32 versus when they're 19.
We had about a 42% recidivism rate when I was a county commissioner in Oakland County, and then when I did work at Children's Village. Question for you, would this bill hypothetically a school shooter to get out in possibly 10 years with the parole board, and the parole board's unelected, but they do the best job they can? I just want to know that under this one, could it happen that a school shooter would be released in 10 years?
Hypothetically, if someone were to come forward with that case and we were to pass this bill as exactly as proposed, yes. You know, given what I've seen out of the parole board, that would be a vanishingly small possibility that would happen. But since your question was posed as like, technically, would that be possible under this language as proposed? Yes, it would.
Okay, thank you so much. I appreciate it.
Any other questions from committee members? All right. Well, thank you very much. I know we've got a lot of folks who want to speak both in support and opposition. So we want to make sure that we're getting to everyone. So if you can keep your remarks to 2 to 3 minutes, that will be amazing. First, we'll bring up Ronnie Waters and Felecia Waters from Safe and Just Michigan. There is a little button at the bottom of the mic to turn it on. There we go.
Okay. Good afternoon, everyone. Can you hear me? Good afternoon. Okay. Thank you. My name is Ronnie Waters. Thank you, Madam Chairman and members of the committee, my name is Ronnie Waters, and I'm a community engagement specialist with Safe and Just Michigan. I was 17 years old on the worst night of my life. The night I was handed a weapon and told it had more strength, just a little more strength than a BB gun. But by the time I knew better, it was too late. My actions resulted in the death of an innocent woman. I agree that I had to be held accountable, but I never agreed that others said about me that I was incorrigible or a monster. At sentencing, I was told that I would live out the rest of my days behind bars. I couldn't comprehend what the rest of my life meant. I was only 17. Other people my age were struggling to decide where to go to college or what career paths to choose. I was struggling to understand why the state had sent me to prison to die, not to grow old, but to die. The sentence told me I was beyond change. The sentence told me I was beyond change. When they sentenced me to life without parole, they were saying that you are beyond change, that you are, they don't even want to discuss it anymore. You just go to prison to die. And at 17, 18, when I went, it was impossible for me to grasp what that really meant. I just couldn't do it because to a 17-year-old, life is 17 years. You may look similar, sound similar, or even see the world in a similar way, but you have had many experiences since then. Those experiences have led to insights and wisdom that change how you interact with the world. The same was true for me. Everyone was young once. Everyone made mistakes. Everyone knows that after you get a certain age, you look back on your life and you say, wow, that was stupid. Wow, I wish I could change that. And we all know that we just change. We become mature. We see things in different lights. We see things as adults. And when you have life without parole, you're sitting in a cell, and as you age, as you become more mature, as you try to educate yourself and become more of a human being, you age out of all that dumb stuff that you went through as a child. And you just want to try to show someone that you have redeeming qualities. You want to try to show them that you're not that person that they talk about in the paper. You're not that person who took an innocent life for nothing. I think about that quite often, even to the day that I'm free, about the harm that I did to my victims. And I'm just out here trying to make a difference, trying to show people that we can change, that we have value, and that we're just looking for the opportunity. Because I realized the extent of the harm I caused, I became committed to making Michigan safer and more equitable for all. Although I've been sent to prison for the rest of my life, I prepared my life on the outside anyway. I prepared for life on the outside anyway. Hope is strong. I completed my GED in prison, came within a few credits of earning my bachelor's degree before they took away Pell Grants in prison. Even when I took vocational training and other classes to improve my education, I also came to terms with what led me to prison, what sort of prison I wanted to be in now that I was there. I mean, I had a choice, you know. There's a lot of bad things to go into prison, and there's a lot of good things to go into prison. So you have a choice, whether you could try to educate yourself, even with a life sentence, whether you could try to educate yourself, whether you could try to become a better person, or you could just say, I don't care. They gave me life, and it's going to be a problem dealing with me. I chose not to be like that. I chose to just concentrate on becoming better, and hopefully one day smart people like yourself could see that change need to be made. Finally got my chance at re-sentencing, and I was released in August of 2020. Since then, I worked on registering people to vote, informed them about new clean slate expungement opportunities, get people engaged in Michigan political process. Hang out with us, and you will see. I got this prepared, but I'm just trying to come from. If you be around a lot of former juvenile lifers, you will see that we're all trying to do positive things out here. I know there's people who's concerned about the Senator Johnson spoke on, about the social pad, the person with no conscience, but all the juvenile lifers have been released so far. That hasn't materialized yet. There's been no one has done any violence. A very, very small percentage have had any encounter with the law. So we got a track record to stand on. Just look at the people that they've released and look at what they're doing and how they live their lives now. It's a track record. We don't have to guess. And you will see we out here trying to make a difference. And the thing about us, we're like a close-knit group, and we believe in helping each other. We believe in if one of us failed, then all of us fail. So we're not going to let anybody fail. So we stay in contact, and we talk about different issues and stuff, and we just support each other. No one's out here doing anything that concern any of you. So that's a good thing. It's data to back this up. Because I lost my freedom so young, we don't take freedom for granted. Statistics show, according to a 2020 study by Montclair University, released juvenile lifers from Philadelphia had a recidivism rate of 1%. And I don't have the exact data for Michigan, but I'm sure we are on par with Pennsylvania. We are probably lower than 1%. Letting children sent to prison die. It's just wrong. It's just wrong. And I hope that you all will see how wrong that is, and we can bring Michigan in accord with the majority of the rest of the nation and end life without parole for juveniles. Thank you. My wife would like to say a few things.
Thank you, Madam Chairwoman and members of the committee. I'm so thankful to be sitting next to this gentleman here. I'm also really thankful to be sitting before you today. For over 40 years, my moments with him were scarce and fleeting. Ronnie and I have been friends since 1972. I know I'm telling my age, but we later became high school sweethearts in the 80s. The incident that he's referring to happened in 1980, and when it happened, it broke my heart. When I learned that he had been arrested for killing someone, it was a lot. And when I started hearing about the way he was described in the media, it just broke my heart again. I mean, they were saying things like he's monstrous, he's irredeemable, he's incorrigible. And I knew that's not the person that they described, that was not Ronnie. they decided to, when he was sentenced, they decided to throw him away. He was sentenced to die in prison. The state gave up on him, but I didn't. His family didn't, because we knew who he really was. We never gave up on Ronnie. Of course, he and I are just a couple years apart, so I did go on with my life. I served in the Air Force. I earned an associate's degree. I earned bachelor's degrees and master's degree. But even going through all of that, my heart was always with Ronnie. He went to over 20 different prisons. When there was overcrowding in Michigan, they also sent him to Virginia. And all of those prisons, including Virginia, I was there. We've always remained friends. When he was in the UP, I organized carpools because some family members could not afford to travel that far, or older parents could not physically drive. So I organized carpools and drove people back and forth. That was just another opportunity for me to visit him as well. I work with organizations like the ACLU. With the ACLU, they begin to challenge the very idea of sending children away to prison for life. And I work with them to end these sentences. The United States is the only country in the world that does this to children. Even the U.S. Supreme Court ruled mandatory juvenile life sentences unconstitutional more than a decade ago. And Michigan is one of the few states that still does that. Among these states, Michigan accounts for quite a majority of the people, children that are incarcerated. How strange is it that Michigan was the first English-speaking territory to ban the death penalty, but also is the world leader for sending children to prison to die? We know better. Science has shown us now that adolescents' brains aren't yet fully developed by the age of 18. Young people don't have the same decision-making abilities. That also means that young people are very capable of changing and learning from their mistakes. Our courts have recognized this, both the U.S. Supreme Court and the Michigan Supreme Court. This past summer, the Michigan Supreme Court called juvenile life without parole sentences cruel and unusual punishment. Having seen these sentences due to people and their families, I've seen firsthand what it's done to their families and how it's a loss in the community. These bills will codify those Supreme Court rulings and make sure no other family will watch their children grow old and die in prison without any hope of coming home. No one is asking you to excuse what they've done. No one's asking you to sugarcoat the harm that was done. We're just simply asking you for a more thoughtful approach to these tragic situations. Please take swift action to pass these bills. Thank you for your time.
Thank you both for your testimony and for sharing your stories. We do have a question from Senator Runstead.
Thank you for coming, and it's wonderful to hear this story of how Ryan has redeemed himself in prison and out of prison. I've got one very good friend and one acquaintance. Both of them spent years in prison. I've talked to them a number of times. Both completely redeemed themselves, became very high members of society. However, in discussing them, and I had read two psychopathy that were this big. And, with a psychopath or a sociopath, the worst thing you could do is give them therapy, because they take that therapy, and how does the average person think? It doesn't reform them, it helps them con people better. And in prison, as they described it, there's good people and there's bad people. And you kind of pretty quickly learn who you can trust and who you can't, who the sociopaths are. They were telling me that usually it's the rapers that are the worst, and one of the things they do is get into your space. They want to see how you act when they're close in your space. If you don't get them out of your space, then you're going to victim. These rapers are not, they're the worst psychopaths and sociopaths of all, and they're not redeemable. They're not. So concern is that someone like yourself, who's proven probably, if you were in prison, I was going to talk to people that knew you in prison, would say Ryan was a guy who did this and this, the right things. But they also tell me about that other side. What I'm concerned about here, that we're throwing everybody's redeemable, everybody's good, no. They have 20 years for each one of these guys told me how it works. So my concern is that we have already resentenced 193 of them. Only 8 are we holding to a life sentence. That seems like a pretty good rate, and I'll bet you if everybody in this room heard in the testimony what those 8 were like, everybody in here probably say, don't ever let that person out. Anyway, that's my concern, but thank you again for coming in.
All right, thank you. I would just say that it's a process. You have to go through psychological evaluations. You have to go through not only through the judge, you have to go through the parole board, and you have to, they look at your entire file, and just because you're getting close to or you're now eligible for parole, that doesn't mean that you're going to get parole.
No, if the bill passes at 60 years, you are out. Doesn't matter if you're the worst monster there is, you're out if these bills pass.
But they can hold you for up to 60 years. You would be in your late 70s.
That doesn't mean there's a lot of late 70s that are monsters beyond belief.
Okay.
All right, to move on. Thank you both very much for being here and sharing your really important testimony. We are limited on time, so again, want to remind folks if you can keep your remarks as short as possible, that would be great. And I'm going to bring people up in pairs. So if we can have Judge Jeffrey O'Hara, retired from the Wayne County Court, as well as Jessica Zimbelman from the State Appellate Defender Office, both come up. Yeah, I'm just going to try to.
Members of the committee, my name's John O'Hare. I represent the Michigan Retired Judges Association today. And I do have experience in the criminal justice system, 18 years as the Wayne County prosecutor and then 15 years as a Wayne County Circuit Judge. The question of life without parole is simple, and yet it's also complex because it has a lot of ramifications. Probably the most significant is the Department of Corrections affording programs to give an individual who is sentenced to prison means to basically work on reform, and we don't have that today. But when I look at the question of is life without parole a viable sentencing option in Michigan today, my answer is, for the most part, no. The source that I look to is the Supreme Court decision in Miller versus Alabama. In that case, the Supreme Court said that a mandatory life sentence offends the 18th Amendment, and that transfers to the states through the 14th Amendment, because it does not afford an opportunity to they call them the offender, to demonstrate that there's reformation and that they are now a suitable individual to be returned to society. When they say, what's the answer? The individual has to have a hearing, and not just a hearing, a meaningful hearing, where there's the opportunity to set forth the basis why reformation has occurred. We don't have that today under our sentencing system. Under our sentencing system, you have the trial, you have the completion, you have a brief interlude for the preparation of a pre-sentence report, and then the judge imposes sentence. There is no opportunity whatever for a defendant to demonstrate that there's reformation because there's been no opportunity for reformation. And until we afford a meaningful opportunity in the hearing, all the sentences, all of them, whether you're 15 or 70, offend the 8th Amendment and thus the 14th Amendment, in my judgment, are basically constitutionally infirm. What's the answer? I'm not sure that I have an answer, but if I was the master of the faiths, I would say, let me go back one point. Miller versus Alabama dealt with the situation of a past offender. There's already conduct there that can provide the basis for a meaningful hearing. But as to the future, there's nothing there. And you can't have a hearing without knowing what happened in that period of time that the individual was incarcerated. There's no evidence whatever. You might have a psychiatrist or a psychologist express opinion, but that's not enough. That's not a meaningful opportunity to the offender to set forth the basis for reformation. I believe that, again, firmly, that there is no basis for a lawful life without parole sentence that exists in this state today. How do we cure that situation? For the offender who's going to occur tomorrow, he is sentenced. At some period of time during the course of that sentence, he is afforded, as a matter of course, a hearing before the parole board, a hearing where he can demonstrate to the members of the parole board that I've done this thing, I've taken advantage of all the available meaningful programs, I'm remorseful, I understand exactly what I've done. I'm a different person today than I was 15 or 20 years ago. I really have changed. I can go into society and I will be a meaningful participant and I'll live a normal life, which is important. The parole board will make the determination. You'll hear the story and determine whether or not this individual is suitable. Has there truly been reformation where we can send them back into society safely? I think that's the way the problem should be handled, frankly. Those are my brief thoughts on it. I know time is limited, and I'll just...
Thank you. But we'll take testimony from both and then do questions. We got to keep moving here.
I just got a question for him. You keep referencing the mandatory life without parole. That's gone. It's gone. You keep going over and over again. What we're talking about is not the mandatory life without parole. There is no mandatory. This has been ruled illegal.
Well, I'm not talking about mandatory.
No, it's the courts have ruled you can't get mandatory.
I understand
So what we're talking about is altering all of the other provisions. Yes, all of these people who went, this 193, every one of them had to go back into court and listen to all of you talk about what kind of prisoner were they, what is all the redeeming factors, all of that, and almost all of them were resentenced to a lower thing. But I have a question for you, Judge. How many juveniles did you sentence to life without parole when you were on the bench?
None.
None.
I couldn't do so. I had no basis for it under Miller versus Alabama. I couldn't do it. If I did it, I would be imposing an unconstitutionally infirm sentence. You know, I'm sorry if I misled you. I'm not saying that mandatory sentences exist. They don't. Absolutely not under the Miller. They're gone forever.
Yes.
What we're talking about is you have a discretionary determination as to whether or not.
All that's taken into account. That's why these people were all reduced sentences. They didn't just pull names out of a hat.
Well,
Do the
those
whole-
are
the whole court
those
again.
are the cases where the conduct has already occurred. My focus is on what are we going to do for tomorrow and the rest of the
Mine too.
eternity.
Mine too. I'm terrified of what's going to happen.
Okay, we have 6 more people and about 12 minutes left. So, Jessica, if you can keep it short and sweet, that would be really helpful. Thank you.
I will do so. I don't know if Jose Burgos from my office is going to join by Zoom, but I'll start talking and maybe he will appear on the screen. My name is Jessica Zimbelman. I'm a managing attorney at the State Appellate Defender Office. I'm also here on behalf of the Criminal Defense Attorneys of Michigan. Kids are different. We know that. And we know that they are constitutionally different for the purposes of sentencing. And in the 11 years since the U.S. Supreme Court decided Miller, we have seen that come true in 3 ways: the law, the results, and the people. And as a lawyer, I'm going to talk about the law first. Miller talked about how the decision in Miller was rooted not only on common sense or what every parent knows, but on science and social science as well. And you should have in front of you a report from Dr. Daniel Keating from the University of Michigan where he talks about the brain science of a young person's brain and how that matters. But the Supreme Court said the distinctive attributes of youth is what reduces the justifications for the harshest possible sentence for a young person, even when they commit terrible crimes. No opinion in Miller or the program that preceded it or since has made a distinction based on solely the type of homicide that was committed. These are all tragic cases. Somebody has died in each of these cases. But those distinctive attributes of youth are a lack of maturity that lead young people to be reckless or impulsive. They're more vulnerable to negative influences and pressures. They have limited control over their environments and horrific circumstances that lead to crime. And their traits, of course, are less fixed, and their character is less formed than adults. And court after court has repeated those in Montgomery and Jones by the U.S. Supreme Court, how kids are different. And then last summer, our Michigan Supreme Court in People v. Parks extended the holding of Miller to those 18-year-olds, which of course this bill does include 18-year-olds, and talks about how those distinctive attributes of youth from Miller also apply equally to 18-year-olds. They relied on science, and they said that this is an especially cruel sentence for an 18-year-old whose brain is still being rewired. And that makes it severe and cruel for these 18-year-olds as well. So that's a brief summary of the law. I want to talk briefly about the results, and you have a one-pager from Sato that kind of outlines the results that we've seen since the Miller decision. Sato has represented 59 people who have been resentenced to a term of year sentence. There have been 38 contested hearings, 29 resulted in a term of years, and 8 resulted in LWOP, although 4 of those sentences were reversed by the Court of Appeals, and we do expect more reversals in the future. Sato has also received 10 reversals of LWOP sentences imposed at Miller hearings where Sato was not of counsel. It's a lot of numbers, but what that means is that trial court judges and Court of Appeals judges are recognizing that kids are different, and they should be sentenced as such. And third and last, I want to talk about people and the people who have come home. You've heard from Ronnie and you might hear from Jose, but about 200 people released in Michigan so far, 2 have reoffended, and they have not offended with another homicide. That puts the recidivism rate at 1%, which is far below Michigan's general recidivism rate of 24%, that number being the lowest that it's been in a long time as well. But again, this is about more than numbers. It's about people. People who make our communities better. You've heard Ronnie, you'll hear from Jose, and you'll hear from other impacted people. We have another Sato staffer here who's a former juvenile lifer, Lorenzo Harrell, who is in the audience today. He makes our Sato better, and he makes his community better. In your materials, you'll see a document called Sato Project Reentry Triumph Reports. I encourage you to read the stories of the people who have come home. These people who have come home are living the promise of Montgomery, of Parks, and that promise is young people are capable of great change. These bills would enshrine what judges from circuit courts all across the state to justices on the U.S. Supreme Court have said time and time again, and that is that kids are different. Thank you for your time this morning. this afternoon.
Didn't Jones cut the legs out of Montgomery?
No.
That's it?
All right, thank you. We're just trying to figure out timing for the next committee. We do have a question from Senator Runstead.
Just real quick, reading here, it says Sado is only aware of to whoever he offended. Why isn't there any firm data? When somebody says, well, I'm aware, that doesn't really mean a lot to me. They're aware. Why isn't there any firm data on that?
Though we don't represent every single juvenile lifer who has come home, and we didn't want to mislead the committee into saying there was no, we reported what we knew, which is that 2 people have
The
reoffended.
implication sounds like that's, hey, just, there's almost virtually only two that were aware. I mean, it really is, I think, misleading. It's a meaningless thing. Also, the sponsor has not read this Montclair state study. I haven't. I know that these studies can be cooked, the books, every way from Sunday, so I'll have to read that before I can be assured that 1.14% is the recidivism rate when Senator Johnson used to work at Children's Village and said it was about 46%. So there's a big disparity we got to kind of work out here. Thank you.
Thank you, Senator.
Thank you. All right, I believe we have Jose Burgos on Zoom. And again, a reminder to try to keep your comments to 2 to 3 minutes. Thank you.
Thank you very much. Thank you to the committee for allowing me this opportunity to testify. Again, my name is Jose Burgos, and I am testifying today to express support for passing Senate Bills 119 to 123. The bills proposed making justice involve children ages 18 and under ineligible to receive life without parole sentences. I am a formerly incarcerated person who was sentenced to life without parole as an adult for a crime resulting in the tragic loss of life because of my deeply regrettable actions at age 16. As a result of the landmark Miller v. Alabama ruling decided by the U.S. Supreme Court in 2012, I was one of the fortunate people to be resentenced to a term of years and released after 27 years. Following my 2018 release from prison nearly 5 years ago, I became employed as a reentry specialist for the State Appellate Defender's Office Project Reentry. I was also elected as a member of the Michigan Bar Association and Prison and Corrections Section Committee. And in 2021, I was appointed to the Michigan Committee on Juvenile Justice by the Honorable Governor Gretchen Whitmer. The majority of Michigan juvenile lifers who have disproportionately received life without parole sentences, more than 70%, have been children of color, despite only being 27% of the child population. This grossly disproportionate sentence is a discriminatory and unjust policy that has no place in a modern criminal legal system. Approximately 76 juvenile lifers who were arrested for capital offenses between the ages of 14 and 17 and sentenced to mandatory life parole sentences still await the opportunity to receive a term of year sentence. This remains the case 11 years after the 2012 U.S. Supreme Court ruling. Since 2012, 7 Michigan juvenile lifers have died in prison while awaiting the opportunity to be released. 2 of them died after being resentenced to a term of years. For those people, life without parole was a death sentence, a punishment not allowed by the Michigan Constitution. The cause of resentencing delays has largely been due to prosecutors seeking life without parole sentences against youthful offenders who are not irreparably corrupt. Senate Bills 119 through 123 will ensure that justice-involved children are held fully accountable for committing harm proportionate to their age and culpability. Minors will also be afforded the opportunities for release consideration later in their adult life based upon evidence of demonstrated change, maturity, and rehabilitation. To date, a remarkable less than 1% of juvenile lifers released from prison after being resentenced to term of years have recidivated. In terms of public safety, juvenile lifers can be considered low-impact releases. For a juvenile lifer, as a juvenile lifer who has transformed his life and witnessed dozens more former juvenile lifers do the same during and post-incarceration, I reject the notion that any child is born bad, that justice-involved children are irredeemable, or that their lives are disposable. Any reasonable adult or parent recognizes that identity development never ceases. The person and adolescent will become is not the person they will remain. The process of self-identification and redefinition lasts a lifetime. I urge you to pass Senate Bills 119 through 123 out of committee and vote to support the bills when they are brought before the entire Senate for a vote. I believe the bills provide a humane and forward-looking approach to holding justice-involved children accountable for harm they cause that balances public safety, mercy, and common sense. Thank you very much.
Thank you very much. I'm going to now next bring up Jeff Getting, who is the Kalamazoo County Prosecutor. Welcome back.
Good afternoon, Senator Chang, Chair Chang, senators of the committee. My name is Jeff Getting. I'm the Kalamazoo County Prosecuting Attorney. I promise I will be as brief as possible. I want to tell you a couple of other things. I'm also the chair of the Legislative Committee for PAM. I sit on the PAM Board of Directors, and I am the president-elect. I am speaking here on behalf of PAM. Yesterday, our Board of Directors, which includes representative prosecutors from the Upper Peninsula, Northern Michigan, Western Michigan, Eastern Michigan, Southwestern Michigan, and our largest counties in Southeastern Michigan, met and discussed these bills and voted unanimously in opposition. These bills are not a codification of current law. The United States Supreme Court has never held that life without parole is unconstitutional as to any juvenile. They've held that the automatic imposition of life without parole is unconstitutional. The Michigan Supreme Court has never held that life without parole is unconstitutional. They have held that the automatic imposition of life without parole is unconstitutional. These bills do not codify current law. These bills go beyond current law and prohibit the imposition under any circumstance for any juvenile of the sentence of life without parole. The Michigan Supreme Court, the United States Supreme Court have never said that there is no circumstance where life without parole would not be a fair and just sentence. They have said that imposing such sentence requires that there be a hearing and a process to determine if that is a fair and just sentence. That is the state of the current law, not Senate Bill number 119. I would also encourage you to look at Senate Bill 120. As Senator Johnson brought up in her question earlier, this way with truth in sentencing for our defendants convicted of murder who are of the ages under 19. Regardless of the sentence imposed by the sentencing judge, whether that sentence was years or 25 or 40 or 50 or life without parole after a hearing, these bills would mandate that there be a hearing, a parole hearing after 10 years. So for instance, if there was a school shooter who committed a murder and killed 2, 4, 6, 10 students at one of our local high schools and received a sentence of 25 years in prison, those victims' families, that community, that school, would be appearing at a mandatory parole hearing after only 10 years. Before their children, 25 years old, they would be at a parole hearing where, mind you, the rule changed. The rules now are presumptive parole. That's what you passed a couple of years ago. That school shooter would be entitled to parole unless there was a decision otherwise. Going into that hearing, presumptive outcome of the hearing is that he be released. That is what Senate Bill 120 says. What our law is simply leaves open the possibility that there is a juvenile, someone who is of such sadistic qualities, or a school shooter, or an individual who planned and plotted and murdered an entire family, a juvenile who murdered an individual, cut off their head, and then drove around with it in his vehicle, that there remains the possibility that that is a person who deserves a sentence of life without parole. Senate Bill 119 takes away that very possibility. Prosecutors around the state do not think that every under 19-year-old person convicted of murder should be sentenced to life without parole. That is obvious from the hearings that have been conducted since Miller was decided by the United States Supreme Court. We are in favor of juveniles having the opportunity at second chances. But we are also in favor of juveniles who have committed the most horrific acts facing that ultimate consequence of the possibility of life without parole. And these bills take away even that possibility for the most deserving. The person who beats to death a married couple that are 85 years old and their 63-year-old dog with a baseball bat in order to take away what she can carry from their house. Or who plants explosives in a school, or who takes a weapon to school and kills other children. We're simply asking that you do what these bills are purported to do. Codify current law. Leave current law what it is. This does not codify current law. This takes away the possibilities that current law, that the United States Supreme Court, that the Michigan Supreme Court say are appropriate. Thank you.
Thank you very much. And we have a question from Senator Runstead.
Thank you. I'm glad to see the prosecutors standing up across the nation. We're experiencing massive explosion of crime with all of these new justice initiatives. And I believe this is going to be one more of those. So now we here's why we have to have this huge change of 193. They say 8, but then we learned from the last testimony, 4 of those were reversed. So we're at 4 people out of 193 that have been resentenced that are going to be life. And I'll bet you if the whole state of Michigan could hear the testimony on what these people are like, they would agree. This says no, after 60 years, they must be released no matter what they're like in prison, no matter how egregious their behavior, they are going to be released. And people say, well, if someone's in their 70s, they can no longer commit a crime. Come on, of course they can. So, I mean, it's just outrageous. I'm so glad you're here. We hear testimony from what people that are really, I think, reformed themselves. And we're going to probably hear a lot more. Wonderful people. I know people. They're totally redeemed their lives. But the implication is every single one of them in prison right now is these kind of people. And it's untrue. There are at least 4 here that should probably be mandatory, and this bill removes that possibility. Thank you.
In response to what, and I just want to make sure that something else is said. The United States Supreme Court, and then subsequently the Michigan Courts of Appeals and the Michigan Supreme Court, have made it exceedingly difficult, very, 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 very hard for a judge to justify a sentence of life without the possibility of parole for a juvenile. As you have said, as the statistics indicate, there are only a couple of people who that sentence has been imposed on and had that sentence upheld. This bill takes away that possibility for even that handful of people. Michigan prosecutors we throw our hands up in terms of trying to prove these cases to a sentencing judge, to get a Court of Appeals or a Michigan Supreme Court to uphold them. It is incredibly hard to get to life without parole as the rules currently are. There is no reason to change that. Absolutely no reason to change that. Thank you.
Thank you very much. Up next, we have Deborah LaBelle from the ACLU of Michigan. And just to note, we are over time, but we do want to hear from Deb. And then, unfortunately, we are likely unable to get to everyone, but we will read in cards and always welcome written testimony.
I want to respond to some of the, overall arching comments and concerns here. I certainly agree that bringing up people, and there are 175 people who have been released to date out of the 363 that Michigan originally had serving mandatory life without parole. Of that 175, they are doing remarkably well. And for Senator Rumstead, I can assure you from the Michigan Department of Corrections, I have the data, there are 2 people who have recidivated. They have not committed any physical violence. They were in possession of firearms, and that has been their recidivism. But I do want to address the people who are left behind. There are, in terms of public safety, looking back 100 years, there is one person who's made it 60 years inside who came in as a youth, and he died shortly thereafter. The life expectancy, as you might, what we call cradle to grave sentences, is quite shortened. And so a 40 to 60 year sentence is essentially a life sentence if you have concern about a damaged individual who can't rehabilitate. And what we're talking about here is that there are 320 people who have been resentenced to date. I know Sato spoke about 193. Those are the ones they've handled. But statewide, 320. 26 of them got life without parole again, and 43 are still waiting 10 years after Miller abolished the mandatory sentence of life without parole to be resentenced. And they're waiting, and the prosecutor seeking life without parole on those sentences. So we're not talking about 8. It's true that the Supreme Court of the 26, the courts reversed 10, and the others are being sent back for resentencing. But in Kalamazoo alone, we have someone who's being resentenced now. Because each time he comes back, they seek life without parole, and each time he goes back again, the courts say, no, you cannot do this. You can't look into the future and determine what a child is going to be like in these circumstances. We just don't know. And so when you're talking about the kind of situation that's going forward, why do you want to get rid of life without parole? I think beyond the futility and cost, what we know is of the ones that got life without parole again, the majority were a result of only 10 judges. There is deep inequity about what's going on here. 10 judges out of 250 circuit court judges are responsible for the life without paroles. And many are getting reversed, it's true, but partly it's this kind of futility and the lack of hope. With due respect, in Kalamazoo, that lack of hope, one woman waiting to get resentenced 10 years after her sentence was declared unconstitutional, committed suicide very recently. And it's what the Department of Corrections says, give them hope. We do not want children in here, and Patricia Crusoe has spoken of this as the former director. We do not want children coming in here with a lack of hope. It doesn't do anybody any good. We want people coming in here who work to rehabilitate themselves. And so it's the concept that if you say, no, we know you will never rehabilitate yourself. And I see Senator Johnson is gone, but she talked about sociopaths. There's a reason that the Psychiatric Society says you cannot diagnose someone 18 and under as a sociopath. Unfortunately, teenagers hit 4 of the 8 categories just being teenagers. They lie, they blame other people, that's the second criteria. They have some anger, and they're irresponsible. So they say you can't diagnose that. You could diagnose half of the teenagers and half of our children with sociopathic characteristics when you hit 4 out of the 8 criteria. We don't know. And I think that's what Judge O'Hare was speaking about. Going forward, you don't have the record to determine if you're going to be reformed. For the Montgomery, for the people looking back, we know we can look at the record and we say, listen, they haven't had a misconduct in 20 years. If they were a sociopath, wouldn't you see any evidence of violence? There has been none. They have grown up, they've reformed, they've out of a toxic environment. And so, they now have become the person they're capable of being. And so to start at the front end at a 15-year-old and say, we give up hope. We say you cannot be redeemed. You cannot, under any circumstances, rehabilitate yourself. No one can say that. And saying that, as a society and as an estate, I think that's why the majority of states have said no. As a state, we're not going to say that to our children. It may be that at 60 years, the parole board will say after 40 years, you're so damaged we can't let you out, 50 years, and they die in there. They may, sadly. But what you can't say, and what all the states have said, you can't say that we will give up hope on you, and we know for sure you will never get better. And I want to speak to the prosecutor's unanimous opposition here. I've been doing this work for a while. They unanimously opposed Miller, unanimously, said they should all be mandatory. They unanimously opposed Montgomery. They said it shouldn't be retroactive. Those who are in there should die in there. They have unanimously opposed every change, and I get that. It's a tool for them, get a plea, threaten life without parole, get a plea. And there are some people that are damaged, but they don't know who they are. None of us know who they are going forward. And so you have Michigan, Mississippi, Georgia, Alabama, Louisiana, Florida, the 2 Carolinas, Oklahoma, Tennessee, Idaho, and Nebraska is the only states who either have not given this up or continue to do it. There are states around us, Ohio, Illinois got rid of it, Michigan, Indiana still has it, but they only have 3 people, and they haven't continued to do it. Wisconsin, 8 people. New Hampshire, 2, and they all have bills coming. Why? Because it's a thing about telling our kids that no matter what happened to you, no matter what your abuse, we give up on you. And there's no need for it. And with regard to the judges here, there have been 39 other former circuit court judges from 16 counties that have, and we will submit it to the committee, that have supported this abolition. There are 16 former prosecutors. There are 10 former heads of the State Bar of Michigan. There are 7 U.S. attorneys. They're all saying that we do not want to be exceptional anymore. Last year, the Inter-American Commission on Human Rights singled out Michigan. They said, Michigan continues at the largest number to do this to their children, and it's a human rights violation. It violates treaties. And our children are no worse than anyone else, and we shouldn't give up on them. Thank you.
Thank you. Question from Senator Runstead.
First off, this constant reference to children, and using that state by state, we don't know how other states define children. I'll bet they don't define it as 18, 19. In fact, no state in the nation defines a minor as 18, 19 and up. So we don't know how other states are having. We don't know. Are they defining children as 14? We don't know. When you say it's a death sentence to get a 40 to 60 year sentence. So if you're 18 and you're 58, you're dead. I never knew everyone died at 58. It's not a death sentence. And lastly, I read 2 books on psychopathy that were this big, very detailed. I read them a number of years ago, but about 40 years ago, this individual psychologist wrote the Bible on psychopathy. And he had a checklist, I believe there's 46, if I remember, different factors. You had to sit down extensively interviewing this individual and getting all the feedback from multiple sources to make that diagnosis. Isn't it 6 things? Oh, they lied, psychopathy, sociopath. It's not how it's done. It's a very, very intensive. And yes, can you identify that at 18? Absolutely you can, just as much as you can at 70. It's very intensive. It's not a simplistic little thing to come up with that diagnosis. But if that diagnosis, you've got a good piece of information about how that individual will act the rest of their life. It's in the brain. It's internal. It's wired, and they've not found a way of undoing that. Thank you.
Thank you.
Thank you. Madam Clerk, will you please read in the cards? Also want to note that I lost it. I know that we originally intended to have Felecia, Warren Gibbs, and retired Judge Meister speak. Apologies that we weren't able to get to you. But Madam Clerk, if you could please read it in the cards.
All of these cards are in support of the package Senate Bill 119 through 123. Mary Cusack, representing herself. Teresa Engelstrom, representing herself. Alicia Bowers, representing herself. Sally Webb, representing all juveniles. Jessica Newton, representing herself and the State Appellate Defender. Claire Wood, representing State Appellate Defender Office and herself, Lynette LeBray, Noah Smith, representing Criminal Defense Attorneys for Michigan, Gabriel Dressner, representing ACLU of Michigan, Ann Coonan, representing Michigan League for Public Policy Kids Count, and Leon Douglas, representing himself in support, Nadia Elanani, representing Joshua Puckett, the Adolescent Redemption and Restorative Program, Bonnie Zabi, representing National Onsite. Nation Onsite, thank you. And in opposed to the bill package, John Hubbard, representing the Hubbard family.
Are we going to have another hearing on this before? This is a massive change in the law. Are we hearing another hearing before we vote?
We will have conversations with committee members and figure out how to proceed. Thank you. Being no further business, the Senate Committee on Civil Rights, Judiciary, and Public Safety is adjourned.